I'd also like to thank Wayne and Carrie for inviting me to speak at this roundtable. First of all, I'm a legal scholar. Well, I consider myself a legal scholar, even though I have a background also in the humanities. So what I would like to say about the current CARICOM claim is that, and it's also been mentioned by previous speakers, is that only focusing on the legal approach to the claim is quite narrow, because of course this is much broader and it involves reparatory justice. But the law can be useful because it's instrumental in providing a vocabulary and providing a language in which to base claims. And it also is, as Bouter also rightly said, that in using legal language, it's also reinforcing the validity of law itself. But I'm not going to deal with the CARICOM case in its entirety, so I'm not going to be dealing today with the whole question of reparations for slavery and native genocide. I'm going to be focusing on one aspect of the claim. And that aspect is actually the full title for the CARICOM claim for reparations is actually Reparations for Slavery and Native Genocide. And if we look at the 10-point plan for reparations, we see that in point 3 of the plan, specific reference is made to Indigenous peoples development and Indigenous peoples development program. So given my own research here in Leiden, which focuses on the role of law in confronting the past in the Caribbean, especially the Indigenous past. I also look at land rights, cultural heritage, and restitution in the Caribbean. So that's the angle I'll be taking in my discussion today. Some of us here were in Edinburgh last week at the Reparations conference, and this is just to go back to the claim as a whole. Hilary Beckles gave a public lecture, and he talked about Mr. Cameron's recent visit to Jamaica. And it was interesting because he said Mr. Cameron, when asked about reparations, he brushed it off and said, well, we shouldn't be focused on the past, you know, we should move on towards the future, and our nations should work together. Mr. Beckles' hypothetical response to that was, well, if the past isn't important, Mr. Cameron, why do you spend £2 billion a year conserving historical monuments in Britain? And he said, well, you're conservatives, Mr. Cameron, so that means you like to conserve things of the past, values of the past, to bring them into the future. Well, we're conservatives too, so I think that's a very nice way of looking at it. And also there's a comedian, Trevor Noah, who's recently did a comedy piece in the UK about colonialism, and one of the things he said about the Commonwealth is, you know, we're all in the Commonwealth and we have the Commonwealth Games and everything, but there's nothing common about the wealth. So I think, you know, if you're looking at it from that perspective, you can see that the whole reparations issue is about not about winning a legal case, but about making states accept that they have a case to answer, which was one of the points raised in the conference last week. So it is about recognising the past and coming to terms with that and addressing it in various ways and means. Having said that, I don't want to poke. My intention here today is not to poke holes in the CARICOM claim at all, but I think we should analyse the content of the claim, and that's what I'm doing in relation to the Indigenous component of the CARICOM claim. So I think that when we're talking about restitution and reparation, I think there's a lot of literature in the settler society context. So we have a huge amount of literature coming out of the US, Canada, New Zealand, Australia, but these are settler societies, and the situation is very different in the Caribbean, mainly because of issues of state responsibility. So while the majority of the citizens in settler societies might be descendants of the original settlers, in the Caribbean, the majority of the population are actually descendants of enslaved Africans, and a population also severely mistreated by the colonial administration. So when you're also assessing questions of state responsibility, it becomes more complicated. And this is going to be evident when I'm discussing some of the cases here. So what is interesting about the claim is that it's not only the first time that Caribbean states are collectively making the claim for reparations, but also that this component, this Indigenous peoples component, is included within the claim, which to my knowledge is the first time that this is included within Caribbean slavery discourse. So what I want to actually highlight here is what I mean by the term Indigenous. So the Caribbean is a complex region, of course, and the distinctions between Indigenous and non-Indigenous aren't so apparent. So I want to clarify exactly what I mean when I say Indigenous. So the departure point is here taken from a number of sources. The first is actually the language of the Caribbean Reparations Commission itself, which draws a distinction by specifically mentioning native genocide, Indigenous peoples development and land appropriation together. So if we look at point 3 of the reparations plan, we see that it reads, genocide and land appropriation went hand in hand. A community of over 3 million in 1700 has been reduced to less than 30,000 in the year 2000. Survivors remain traumatized, landless, and are the most marginalized social group within the region. End of quote. Second departure point is the language of the United Nations human rights bodies dealing with Indigenous rights, racial discrimination, cultural rights, and land rights, which includes, which views the term Indigenous as a broad term to include Indigenous and Afro-Indigenous communities. So it's a broad conceptualization of the term. And also I'm relying on the language of national population census statistics in the Caribbean as well. And this would be mainly those CARICOM states with self-identifying Indigenous communities. So we're talking about Belize, Guyana, and Suriname in the mainland. And in the islands, we're talking about Dominica, St. Vincent, and Trinidad. But of course, there are other islands with self-identifying communities, even if they're not recognized in the population census. Okay, so it's based on a political, legal, and social distinction rather than a mere biological one. I think that needs to be pointed out. I also really want to make this point here that many communities in the Caribbean feel excluded by Indigenous rights discourse, and that's also very important to notice. Melanie Newton writes about this, and she also writes about the term Indigenous being highly contested in the Caribbean itself. This is something that's going to be future research of mine as well. So if we look at Indigenous reparations in international law, it was touched on by Anna earlier. Traditionally, reparations for Indigenous people can be afforded by two main legal means. The first is a state-on-state approach, and which is what we're seeing here in the CARICOM claim. And the second is a human rights claim, so a claim being brought by a citizen against the state. And of course, the second approach is the result of this gradual evolution of international law to being based on solely between the rights of states and the obligations between them, to also including the rights of individuals and the obligations of states towards their own citizens. So Federico Lenzarini he's written a book on reparations for Indigenous peoples, and he argues that there's also a third way in which reparations for Indigenous peoples can be envisaged in international law, and that evolves from, or it contains a type of relationship that's similar to the relationship between states, and it's obviously much rarer and more exceptional because it's based on the premise that Indigenous peoples never lost sovereignty over their ancestral lands. So treaties concluded between native peoples and colonizers are often considered probative of such sovereignty. And in the US, for example, we can see that between 1787 and 1871, over 650 treaties were signed between the federal government and Native American tribes, and many of these treaties are considered legally binding as well today. So if we apply this third scenario to the Caribbean, we don't have the same body of treaty rights to rely on as in the US, for example, although there are some exceptions, but I'm not going to go into those here. In settler society jurisdictions where treaties have been entered into with the Indigenous populations, then responsibility for those treaties has been found to fall to the newly independent state for the most part. And a major example of this is the Treaty of Waitangi in New Zealand. So even though treaties entered into by the Crown, did not remain the obligation of Her Majesty's government in England, but devolved to the newly independent state. Similar judgments have been reached in other jurisdictions as well. Excuse me, I've got a frog in my throat. So the situation of the Caribbean differs, of course, because unlike other settled colonies, the majority of the island's populations, as we said before, there's not that direct link. So there's no continuity between the administrations that would have passed legislation relating to Indigenous matters and the colonial and independence eras in the Caribbean. So we could also apply the erroneous application of doctrines of discovery here as well, and that's a very relevant discussion. But the problem is that land claims are often met with the test that the people in question retain their traditional lands in order to recover them. And as Shelton points out, this has the paradoxical consequence that the more successful a state has been in dispossessing an Indigenous population, the less likely it is that they will be ever able to recover those same lands. So the recognition of the unlawfulness of titles of conquest does not help the stringent and often essentialized mechanisms of law to prove continuity with native lands. And this also represents one of the many leftovers of colonialism in the legal order. What I'm interested in the Caribbean, and especially in relation to how local communities interact with law, is that international law has a long relationship with the Caribbean region. So some of the earliest treaties of the body of what we now term international law contained clauses, of course, justifying possession of various islands, clauses divvying up and dispossessing lands in the islands. So international law was a tool of empire. And what's interesting is the shift in the use of international law in the Caribbean, because communities are now using international law as a way to gain recognition in the post-colonial context. And this is something that it's termed as international norm diffusion. So international norms and rights are actually being shaped in practice by the communities who see themselves as subjects of those rights. And this is what we can see in the Caribbean. So it's very interesting that we have this shift from tool of empire to vehicle for change, or at least the way in which the law is being perceived as a vehicle for change by communities. So we can see, and I'm not going to go into some of the details here, but I just want to say broadly that we can see that in the Caribbean, if we look at case law concerning things like restitution, especially in relation to land, it's been international courts and national courts upholding international standards which have proved most progressive in asserting Indigenous rights in the region. So examples include, for example, in Belize, we have the case of Cal and others versus the Attorney General, which was upheld by the Belizean Supreme Court in 2007, 2010, and recently in 2015 by the Caribbean Court of Justice. We also have other cases, such as the Saramacca and Moiwana judgments against Suriname, cases in the Guyana High Courts. So we have a lot of case law in terms of the mainland Indigenous communities. And this raises an important point in the current claim, the current CARICOM claim for reparations. So many of the cases, and actually even some of those cases, deal with the question of reparations. And actually it's interesting that Nancy mentioned that the Indigenous communities are working together with the reparationists as well. The problem here, though, is that if we return to the aspect of native genocide and Indigenous development within the plan, within the reparations plan, we can see that the most crucial aspect for Indigenous peoples' development in the Caribbean is the question of land. Yet the structure of the claim is such that states currently found in violation of Indigenous development in relation to land are those making the claims on their behalf. So we have a problem, we have a tension within the claim. So it's absolutely true, of course, that colonial powers bear responsibility for the original dispossession of land, contributing to native genocide. The fact is that that dispossession is being continued in the contemporary post-colonial context. And the issue with land can only be dealt with by the current state. That is, it can only be dealt with internally. The evidence to support this supposition can be found in the case law of the Inter-American Court, national cases, reports of UN bodies, particularly the Committee on the Elimination of Racial Discrimination, all of which place a firm obligation on current governments to recognise land rights of Indigenous peoples, including the Maya and Garifuna in Belize, the Saramacca and Duka communities in Suriname, Amerindian, the so-called termed Amerindian communities in Guyana, and also smaller communities in the islands. So much of my own research is actually based on legal analysis of cases, of UN reports, but also field work, and again, a lot of the feedback, a lot of the perspectives on the representativeness of the current CARICOM claim, they're not coming from my own, the legal analysis comes from my own research, but a lot of this is based on feedback that I have received from communities about land, situation of land within the current post-colonial context. So in the islands, there's an absence of case law, and this is due to the significantly smaller size of the communities, of course. And it's also due to the fact that there aren't the same grave violations of human rights taking place in the islands. But issues do remain with regard to, for example, discriminatory attitudes to Kalinago populations in Dominica and St. Vincent, and land security remains an issue in those islands. But this is already being tackled with by island governments. So the Prime Minister of St. Vincent, Ralph Gonsalves, he recently announced his intention to title Indigenous lands in St. Vincent. He's, of course, his government are leading the reparations claim. Trinidad, the government of Trinidad, only recently, a few weeks ago, has finally granted access to 25 acres of land to the Santa Rosa First Peoples community, and it's a fraction, of course, of the original land that was expropriated from the community, but it does represent a step forward. In Dominica, the government has also recently devised an agricultural support for the farmers living in the Kalinago territory. And of course, some of you will know, in Dominica we have a situation where we have the original Carib Reserve. It's actually the Kalinago territory, and it's been officially renamed that recently. It's a situation of communal land ownership, land tenure. The inhabitants don't want private property. How am I doing for time? 3 minutes. I'm nearly finished. Yeah. So, okay. But the issue is that the land can't be used as collateral for small loans and development. So that places the territory's inhabitants at a disadvantage when it comes to development. So creative ways have to be devised in order to assist the community. All right. So I'm going to skip forward a little bit because I'm conscious of time. Yeah, so I suppose what I want to say is that the Indigenous communities I've been consulting with feel underrepresented in the current claim and wonder whether reparations will change the practices of the state on the ground in relation to land and development. Another issue I'd like to raise just very briefly relates to cultural redress, and I think this is where the obligations of former European governments comes into play. So it's already been mentioned that cultural genocide was omitted from the definition of genocide in the Convention of 1948, but it's been increasingly recognised. This concept of ethnocide has been increasingly recognised, and it's a fundamental element as a sense of cultural loss is one of the greatest looming legacies amongst contemporary Indigenous peoples in the region, and concrete proposals in this regard could contribute to repairing the past, albeit in a small way. What I mean by cultural redress here is not just the return of cultural objects, and in fact, talking to communities in the Caribbean, it becomes obvious that cultural objects aren't so important as other things, other things such as access to historical documents, access to historical maps, which also help with land claims, changing the school curriculum, especially the history syllabus, to reflect a more Caribbean-centred education. But I'm just going to end on two little examples. So when we're talking about cultural space and we're talking about sacred sites, the island of Bali, as many of you will know, was the island where the Garifuna were forcibly removed to this island in 1796 at the end of the so-called Black Carib War. And the island of Baliso is just off the coast of St. Vincent, and about half of the people forcibly removed to this island died within 6 months. And this site is a site of pilgrimage. It's a sacred site, a site of memory, and many Garifuna make the pilgrimage annually to Baliso. Baliso is currently for sale for $30 million US. And one of the interesting things is that in a recent report by the UN Special Rapporteur on Cultural Rights, who visited St. Vincent and produced a report in 2012, made specific reference to the obligation on the part of the government of St. Vincent to preserve the site of Baliso as a site of remembrance for the Garifuna and to ensure their continued link and access to that site. And if we're looking at historical redress, I think that presuming that St. Vincent bears the responsibility for that. There are certain creative ways in which funds specifically addressing cultural issues could be addressed by former colonial governments, in this case the British government. Yes. Okay, so I'm just going to finish. So what I want to say is that, yeah. Yes, I'd just like to say that, yeah, CARICOM states that Indigenous communities do have a responsibility in relation to land rights. Only they can discontinue colonial legacies in relation to land, while European governments bear the task of addressing past wrongs more broadly. Thank you very much.